Good evening, everybody. Welcome to the Southington Town Council. Meeting today is Tuesday, October 20th, 2015 at 7 p.m. And we are located at 196 North Main Street in Southington. This is known as the Municipal Center Assembly Room. Madam Clerk, please call the roll.
Victoria Triano.
Here.
Stephanie Urillo.
Here.
John Barry.
Here.
Paul Champagne.
Here.
Cheryl Lounsbury.
Here.
Don Maselli.
Present.
Christopher Palmieri.
Here.
Michael Riccio.
I'm here, and we have a quorum. I'll move on to item 2, which is the appeal of the Board of Ethics decision regarding Tom Lombardi.
Mr. Chairman, before we begin, I have a prepared statement I'd like to read. John, Dawn, and I have thought about this and have actually agonized over this. We truly believe that we are all too closely connected to this and therefore not able to render an unbiased decision. It's not about Tom or about denying him a right to a fair appeal. He should be guaranteed a fair appeal. As such, every council member should recuse themselves. We are in a difficult position here because we believe there are contradictions in the ordinance. Although it states that the town council is the appeal board to the Board of Ethics, it also states we must recuse ourselves if there is a conflict of interest. Again, I feel every council member should recuse themselves this evening. With that being said, I will not take part in this and will recuse myself at this time.
Mr. Chairman.
Yes.
I am also recusing myself this evening. I don't believe that I can render a fair and unbiased decision on my colleague, Tom Lombardi, who is someone I've gotten to know over the past couple of years and actually admire and respect.
Mr. Chairman, I recuse myself from this matter due to a conflict of interest.
Okay, thank you very much.
Mr. Chairman, may I just make a statement at this point?
Sure.
None of us on this platform are comfortable. This is very difficult. It is a sad and difficult moment for all of us. But when we took our oath, we promised that we would abide by the rules and the ordinances and the charter of this community. In the Code of Ethics, there is no other recourse. I would very much like it if there was another recourse, but I cannot find recourse in here for us to do anything else but to do the right thing and stay where we're elected to be as responsible elected officials. It is not just because it's difficult. We're elected to do the hard thing. And I, for one, will make a promise that I will do the hard thing, and I will scrutinize every single piece of evidence that's brought before us this evening. But to recuse ourselves and to walk away from the responsibility that we have as elected officials is terrible. And so I'm not sure where they felt that was an option. There is no option. We are called to be righteous and upright before the townspeople according to the Code of Ethics and to our charter. And so I will stay, as difficult as it is for me. I will listen to the evidence, and I will render a fair and honest decision based upon what is presented to me this evening. That's my responsibility. As a member of this town council for nearly 20 years, I've never shirked from that responsibility, and I'm not going to start now.
Thank you, Victoria. I think for the benefit of everybody in the room, it would be appropriate. We are sworn when we take an oath of office to serve the residents of the town of Southington to uphold the charter and the Code of Ethics. But I think it would be important, just so everybody understands why this has become our responsibility. Under Section 28-16 of the Code of Ethics, anyone has the right to appeal, and I'm just going to read it for the record. Bear with me. It says, any respondent aggrieved by the action of the Board of Ethics and the disposition made by the referral individual or board set forth in 28-14 shall have the right to appeal the decision of such referral individual or board to the town council. There's an exception in there if you are a member of the Board of if you were an employee of the Board of Education, it would be appealed to the Board of Education. They can do this by filing a written statement of appeal with the chairman thereof within 15 working days after the decision has been rendered by the referral individual or board and served upon the respondent by registered mail, return receipt requested. Upon receipt of such appeal, the chairman shall schedule a hearing within 15 working days. Item B, under that same section, it says, upon such hearing to be conducted by the town council or the Board of Education, as the case may be, such body shall have full, complete, and final authority to take such action as it may deem appropriate. The respondent and the complainant at such hearing shall have the right to present evidence in oral and written arguments. That's it. It doesn't state anything else. So I would agree with Ms. Triano and move forward. At this point, I will turn it over to the party filing the appeal.
Where's Mark?
Yes, is Attorney Schroeder here?
Yeah, he's in the back.
Mark, can you help with the screen, please?
There's a couple of chairs over here.
Yeah, there's a few there. Oh, that's nice.
The seating arrangement, they should break it up a little. For anybody who wishes to be seated, there's a couple of chairs on this side. If you are sitting next to an empty seat, could you kindly raise your hand so these people can sit down? Thank you very much.
Could take these chairs up on the dais.
Mark's getting chairs.
If you would just, as you get a chair, perhaps leave the exit and entrance kind of so people can get in and out. I'm sure our fire marshal would want us to do that.
Can you see that? It's a test page. Now.
Thanks, Gary. Thanks, Mark. Okay, go ahead.
Mr. Chairman, remaining members of the Town Council. My name is Kane Bennett. I'm an attorney. I represent Tom Lombardi. It is my privilege and honor to do so. I was going to spend a good deal of time tonight talking about how this case is about politics, but I think what I just saw proved the point better than I could. You see, this case is not about ethics, and it's not about Tom Lombardi's ethics, which remain intact. This case is about two things. It's about a group of neighbors surrounding the Hatton Field that don't want solar on the ground in Hatton Field. And it's about Mr. Rosenblatt, the Democratic town chairman, using this and exploiting this opportunity for political gain. What's very important to understand is that the complainants in this case are not concerned citizens. They are self-interested parties with a legal agenda and a political agenda. And it is the political and legal agenda that has tainted this process from the very beginning up through the flawed decision that you saw from the Board of Ethics and the incompetent hearing that took place. I'm going to make a lot of comments tonight about the Board of Ethics and what they did or what they didn't do. And I want to make it clear that my comments are not directed to board member Andrew Mead. My comments are directed to the board majority. Member Andrew Mead was the only one who had the courage to say what this case really is. He didn't pretend that it was about something else. He put right in the dissent exactly what's going on here. This is not a case about winning elections, and you don't use the ethics complaint process in this town to try to get votes. And you don't smear a man's name with an impeccable record to try to get votes. And board member Mead put his name to it and said that's what this is about. And he cautioned everyone not to do that. And that Tom Lombardi did everything 100% in good faith. Now, when I got involved in this case, I'm an outsider. I'm not from Southington. So I had a lot of catching up to do with what's going on. And in my review of the record in this case and trying to understand what's been going on from an outsider standpoint was somewhat difficult based on the record. But I was able to, 3 things stuck out to me that I think are important to understand to correct the false narrative that's been created here. Number 1, I don't think there's any dispute that Southington decided as a town to try to save money with solar. I didn't see any objections or anybody saying we're not going to do solar. It was the exact opposite. Everybody wanted to do solar, Democrats and Republicans alike. I saw very favorable comments about not only does Southington want to do solar, but Southington wants to be a leader in solar and wants to bring the kids along in the schools to educate about solar. And let's have the town be a leader in this area. That's number 1. Number 2, there was consensus and unanimous agreement that the town was going to do solar with green skies. There was no objection to using green skies. There were multiple players involved in this town, very respected, hardworking people who vetted green skies and who made recommendations about green skies. And nobody disagreed. The Democratic town council members who walked out tonight agreed to green skies. This is not something that Tom Lombardi created. Number 3, Hatton Field. The idea of doing solar on the ground in Hatton Field goes back a year or 2 prior to May of 2014 when Mr. Lombardi recused himself from a vote. That's before Tom Lombardi was even running for town council for the first time. So this narrative that's been created that Tom Lombardi brought us this solar thing and he brought us green skies and he brought us Hatton Field is just dead wrong. It was already in play for multiple years before any of this happened, and there was consensus across the board that this is what the town was going to do. So somewhere along the way, what happened was, from my outsider's perspective, is that a group of neighbors around Hatton Field, at some point, whether you believe that they didn't know about it or whether they just recently found out about it, it's not particularly important to this appeal. But either way, there's at least 10 to 15 instances of Hatton Field in the public record of this town going back a couple of years. And somewhere recently, in May or June of 2015, a group of neighbors decides, whether they find out about it then or after or before, that they don't want the solar panels on the ground in Hatton Field. Now, something that struck me about that is even when that occurred, you had a vote on June 22nd, 2015 here. And there was an open debate at that vote. Members of the public these were concerned citizens about their neighborhood, expressing heartfelt thoughts. And what was interesting is that debate was open, it was honest, it was public, it was respectful. And members of the town council spoke, and everybody treated each other decently, even if you had a disagreement. 4 days after that vote, something changed with the dialogue and the narrative in this town. 4 days after that vote, Mr. Rosenblatt decided to inject himself into this case. He's the chairman of the Democratic Town Committee. He didn't have to file an ethics complaint against Mr. Lombardi. He wanted to. He signs his complaint on June 26th, 2015, and then you've got a snowball going down a hill. The next thing you know, you have a lawsuit against the town. Now you got a legal case. So you've got lawyers involved, the lawsuit involved, the head of the Democrats involved, and then you've got the media that gets involved. Not just conventional media, but social media. And you have a process that goes from being open, respectful, professional, and turns into a dirty, ugly smear campaign. And that's exactly what happened. A smear campaign against Tom Lombardi, a lifelong Southington resident, a CPA and an MBA, running on town council for the first time, giving his time, his energy, his passion, and his commitment to this town, and not just Tom himself, but his whole family, has the best interests of this town in his heart. And not only did he have an impeccable record prior to Mr. Rosenblatt signing this complaint against him, but he did it the right way. And that needs to be really clear. Andrew Mead stated it in his opinion, but I'll make it clear here. Tom Lombardi did everything he was supposed to do under the Code of Ethics. And not only did he do what he was supposed to do, he went above and beyond what the Code of Ethics in this town requires on at least 3 occasions. The Code of Ethics in Southington does not require a member of the town council to go to the town attorney and get an opinion on a conflict. It doesn't require it. It's available. Tom used that opportunity, got an opinion, and proceeded to vote. So he already did one thing he didn't need to do. Number 2, when you don't have a conflict of interest, you are not required to recuse yourself from any vote. Mr. Lombardi did that. In May of 2014, he recused himself from a vote on the original selection of Green Skies by the town council, after talking to the town attorney and getting an opinion that there was no conflict. But Tom said, you know what, I'm not going to vote because I want to avoid even the appearance of any issue. That is not the standard in Southington. The standard in the Southington Code of Ethics does not prohibit voting based on the appearance of a conflict of interest. That is the code you have. And that was the opinion he obtained from the most knowledgeable person in the town on that issue, Attorney Shoda. Number 3, he was not required to disclose anything on the record in May of 2014 when he recused himself, but he did. He stated his employer does business with the vendor, and he didn't vote. He didn't have to do that, and he did. It's important to consider those facts when you look at the false narrative that's being created in the news media. And the first thing I want to do is try to correct, and this is going to be based on the record of what happened at the Board of Ethics hearing. Correct the record, because there is a lot of nonsense going on in the news media and in social media about what Southington's Code of Ethics says, what it should say, what people think. It's important to remember that when Tom Lombardi went to the town attorney and got an opinion that there was no conflict, that opinion was given to him based on what the town of Southington's code says, not based on what other people are trying to say it says. So let's go. I'm offering some facts to correct the record here. The very first one this is important to understand for everyone because there's been a lot of talk and frankly complete confusion by the attorneys on the complainant side as to what the conflict rule is at issue in this case. I want everybody to understand that the Board of Ethics, as flawed as the decision was, never made any finding of any kind that Tom Lombardi had a personal interest in his vote. That's important to understand. No finding at all that he personally was going to benefit in any way from that vote. The conflict rule at issue here in this case is something that applies to your employer, not Tom personally. The town of Southington Code of Ethics has different types of conflicts. The one at issue here is one that is one layer removed, so it's not even yours. It applies to your employer. So the issue was whether Tom's employer will be affected by the June 22nd, 2015 vote. That's what the issue was. Fact number 2. I just mentioned this. This goes back before Tom Lombardi ran for town council, and there was many respected town players involved in this process. So to suggest that there was something underhanded about the process, including a media story today, actually stunned to continue to see Mr. Rosenblatt in the media when he's the complainant in this case. Fact number 3. He does not work for Green Skies. This may seem obvious to many people.
Excuse me just for a
Yeah.
moment. It appears that when you plug into to the wrong port, so the record unfortunately cannot pick this up.
Oh.
Would you mind just unplugging it and switching to the one on the left side? And we'll just confirm. On my left, I apologize, you were right.
This one? All right. Let me make sure I have it.
Well, tell us who's beeping. They should tell us who's beeping.
Somebody's car.
I know. I parked over there too. On the side of the driveway.
Al, you said that was a red truck that's outside? Al,
What? Can
is
you
that
see
a
the car
red
that's
truck?
beeping?
Is that what I heard you say? No. Oh, okay.
It's
This one is talking.
It should be my car.
I did.
Is that the keys right here?
Does it sound like anybody's truck?
46C W16. Thank you.
Yeah.
Is it not coming up, Kane?
No, it's connected to the HDMI,
Okay.
and that's that cord. So it's reading that cord, not this one, for
Okay.
whatever reason.
I mean, if you could just give me 1 moment.
No
I'm just
problem.
going to go in the back.
Okay, hold on a second.
One more time to see if it, maybe unplug it, plug it back in. I don't know if that makes a difference.
Shouldn't.
Okay.
Go back to the old way?
Yeah.
Okey doke.
That's fine.
All set?
Yes.
Thank you. Yes, thank you.
All right. This may seem to be an obvious point, but if you read the hearing transcript, he's treated as if he works for Green Skies. That's why I put this on here. This is kind of stating the obvious, but his employer is Centerpoint Development Company. And when you see the hearing transcript, there's a great deal of confusion, or intentional or by mistake, as to the separate entities involved in this case. This is Tom's employer. They are not constructing the solar farm in Hatton Field. And no other center plan entity is either. Several times prior to the recusal, Mr. Lombardi disclosed to not just the town attorney, but the town manager, the relationship between the owner of Center Plan Development and Green Skies. This was not something that was hidden. He didn't have to tell the town attorney. He didn't have to tell the town manager. He did. Without Tom voting, the council voted unanimously to select Green Skies. I believe, if I'm correct, there was 3 Democratic council members who voted for Green Skies at that vote. Like I said before, Tom Lombardi very well could have voted because there was no conflict of interest, but he went above and beyond what is required and didn't do so. This is just to point out that the town attorney's opinion to Mr. Lombardi that he didn't have a conflict was the correct one, based on what the code says, not based on what people want it to say. And it's also important to understand that the town attorney in Southington, it's not the first time he's had to give an opinion on ethics in this town and conflict of interest. 2 years ago, there was an opinion from the town attorney that 2 Democratic councilors did not have a conflict of interest with respect to a vote. They also relied on the town attorney, the same way Mr. Lombardi did. Now at the hearing, there's a typo in there. Yeah. I just noticed that. The contract is with GRE 344 Southington, HES LLC. That's who the town's contract is for solar. There's no evidence in the hearing record as to who GRE 344 Southington is. May 11, 2015, Tom Lombardi voted on the approval already signed off on by planning and zoning. This was not something that the town council created, the idea to have solar at Hatton Field. It came through the Planning and Zoning Commission and was sent up to the town council to ratify or approve. And that's what happened. This was the vote in question. June 22, 2015, Councilor Palmieri made the motion to revoke the prior vote. So there's been a lot of confusion as to what this vote was. And I tell you, if you want to look through the hearing transcript, I'll save you the trouble, but about 50% of that transcript is Mr. Rosenblatt and Mr. Rosenberg trying to figure out what the vote was. They didn't have it right. Mr. Rosenblatt's complaint doesn't have it right. It's a false description of what the vote was. And the vote was illegal because you can't just revoke a matter that already has resulted in a contract with the town. The town was already under contract. There's implications to these things. You can't just revoke something like that. And the point here is that Tom Lombardi's vote had nothing to do with the outcome of that particular vote. If Tom Lombardi didn't show up, if he voted yes, if he voted no, it wasn't going to change the outcome. Now let's get to the transcript. This is a transcript of what happened at the hearing. And for purposes of this appeal, it's really all that matters. And what I want to call everybody's attention to there's a lot of problems that are filled throughout this hearing transcript, but the reality is you don't have to go past the first page. And this statement right here to understand just how flawed this process was and how incompetent the hearing was. This is Chairman Sims, who comes out for the hearing, and he's the chairman of the Board of Ethics, and he makes this statement on the record. This is how the hearing started. We are here to consider the testimony presented by the two complainants. Right? Everybody who watches, even if you watch Judge Judy, you know, whoever brings the case has to prove the case. That's our system of justice. So Chairman Sims is rightfully pointing out, this is why we're here. We're here for this hearing because we're going to hear the testimony of Mr. Rosenblatt and Mr. Bruch, who are the complainants. They're the ones making the complaint, so we're going to hear their testimony. Now, everybody who sees this and is reading it, wouldn't you naturally think that the very next thing that happened is that Mr. Bruch and or Mr. Rosenblatt testified? Wouldn't you at least think? Of course they testified. These are their complaints. Well, if you thought that they testified, you'd be wrong. After making this statement, Mr. Bruch and Mr. Rosenblatt do not testify under oath at this hearing. It's unbelievable. Let that sit in for a minute. Could it be they knew what the result was going to be? I don't know. Or they forgot the rules of evidence? I don't know. Either way, they didn't testify, and it goes beyond that because the Town of Southington Code of Ethics charges the Board of Ethics with the responsibility to investigate. And you're going to see later that Chairman Sims, he's not afraid to call a witness. He calls the town manager himself. He says he's there to hear this testimony. So it's not just the complainants that had an utter failure to present evidence, but the chairman of the Board of Ethics, after saying this, doesn't call them for testimony, doesn't have questions. Not a single question was asked of Mr. Bruch or Mr. Rosenblatt under oath at this proceeding. So the reality of it is you don't need to go through the rest of the 29 pages of this hearing transcript to know that this is a flawed decision, that this should be thrown out. Here's some of the problems, just a few of the problems from the hearing. Now, I already commented on this. Literally, half this transcript. It's a 30-page transcript, and half of it is Mr. Rosenblatt asking questions about the vote, because he doesn't know what the vote is. And even the Board of Ethics members are asking what the vote was. Nobody knew what the vote was. And they actually had to ask, or Attorney Shota had to butt in and tell him what the vote was. And then they asked Attorney Shota for what's the procedure supposed to be. Then they asked Attorney Shota, what is this 824? What is this? And then Attorney Rosenberg actually said in the conclusion of this hearing and asked Attorney Shota to tell the Board of Ethics members about evidence rules, about something to do with evidence. And I found this stunning, that throughout this transcript, everybody's relying on Attorney Shota as the expert, the smartest guy in the room, but they don't ask him about the conflict. They completely ignore Attorney Shota when it matters. The board majority's decision in this case doesn't even mention Attorney Shota's opinion. Doesn't say we disagree with it, doesn't say anything about it, just ignores it as if it didn't happen. And what you're also going to see throughout the hearing transcript is something that's a little disconcerting, because what you have is a process in play where people are confusing the standard. They're talking about an appearance of a conflict, of an appearance of an impropriety. Mr. Rosenberg, that's not the standard in the town of Southington's Code of Ethics. And perhaps the Board of Ethics members, when they hear these kind of statements being made from an attorney, maybe they believe it. I don't know. But they were wrong. Wrong about the conflict, talking about this as if this was Tom's personal conflict, saying that making arguments and bringing up swimming pools and what happens if the town builds a swimming pool on the town property. They end up talking about swimming pools. And then they're talking about, whoa, Mr. Lombardi's going to get a Christmas bonus. No evidence of this whatsoever, just commentary by the lawyers. And then board member Pomposi openly speculating on the record and deliberating. He's announced, you read this in the transcript, you don't have to take my word for it. The members of this town council, I'm providing all of them with a copy of the transcript. I think you already have it anyways. You'll see it. Member Pomposi is on the record going, gee, what if this happened? Or maybe if we conceive of this and we assume this fact and then that happens, we have a possibility of maybe a conflict. And that's what I think happened. And he has to be admonished by Attorney Shota and say, you know what, you're supposed to be in a judicial capacity here. You're not supposed to be announcing what your ruling is and speculating on the record like this. You might want to listen to the other board members, or you might want to finish the hearing. And so he does, but he clearly lets everybody know what his thought process is. So the only person from the complainant or the respondent in this case, which is Mr. Bruce, Mr. Rosenblatt, and Mr. Lombardi, who had the courage to testify under oath, was Mr. Lombardi. Now, I'm not going to go through this point by point. I'm going to summarize it. But Mr. Lombardi was called by Mr. Rosenblatt. And I'm sure Mr. Rosenblatt, when he gets a chance to speak, is going to tell you, I didn't need to testify because I had Mr. Lombardi's testimony. That's what he's going to say. Well, you might think that until you actually read what Mr. Lombardi testified to. And we've summarized those points already. He testified, and he was questioned by Chairman Sims. He was questioned by board member Pomposi. He was questioned by Attorney Rosenberg, and he was questioned by Attorney Rosenblatt at length. And he was called back a second time to answer more questions. He wasn't hiding anything. He faced all the questions. And what he said was, I don't work for Green Skies. I don't work for any center plan entity other than Center Plan Development Company. They have other entities that have their own accountants, have their own staff, are separate businesses. And attorneys know better than to take corporations and LLC and to disregard them as entities. They are separate businesses under the law. They're different entities. They were questioning Mr. Lombardi at this hearing as if his employer was somebody who works for or owns Center Plan Development Company, not the company. And they were eviscerating the idea of separate entities and conflating them all together. So he doesn't work for Center Plan Construction or any other entity. And he made a full disclosure to the town attorney, and he was told there was no conflict and he could vote. He didn't provide any facts about who's constructing the solar farm at Hatton Field. Not a single piece of evidence in the record as to who's constructing that solar farm. Nothing. Not a single fact about finances of any company or delay costs to any company. Nothing. The testimony, the only witness other than Mr. Brumback, was Mr. Lombardi. And Chairman Sims did call the town manager, and I put that in red because I want everybody to understand that the board chairman can call witnesses and call the town manager. And he clarified that there were many people involved with the selection of Green Skies, and the town manager recommended Green Skies, somebody who's doing very good work for the town, putting all his energy into trying to get a good deal for the town, recommended Green Skies. And they even had consultants involved, employees from the town, from different departments. Many players were involved. And Mr. Brumback also testified on the record and clarified that the contract is with GRE 344 Southington HES LLC. What you won't find in the hearing transcript is what that company is, or what that company's relationship is to Mr. Lombardi or Green Skies or Centerpoint or anything else, because it was skipped over and never addressed. And Mr. Lombardi's attorney at the hearing offered the affidavit of Mr. Landino, who is the chairman of the board of Green Skies Renewable Energy. And his attorney read into the record the contents of this affidavit and provided the affidavit to the Board of Ethics members. This affidavit was completely ignored and not even mentioned by the board majority. And this wasn't really new evidence, this affidavit. This was confirming what Mr. Lombardi had already testified to. And nobody questioned this affidavit, by the way. Nobody asked Mr. Lombardi questions and contradicted this. There's not a single piece of evidence in the record that contradicts this. And then we get to the decision. It's a one-page decision. And I'm going to call out the relevant portion of this decision. This is the guts of this one-page decision. The board majority found from this record that there would be an effect on center plan, could have been a delay in construction, and alleged cost of that delay. And Mr. Lombardi's vote could have had a material effect on center plan. Now, I note there's two could haves in there and one alleged. And we're going to talk about what the town's code of ethics actually requires. It's not could haves and alleged. And we just went through the record. There's no evidence anywhere in that record that center plan is going to have a delay in construction costs from this vote. It's simply not there. And if you do a term search on a PDF in the hearing transcript and you put the word delay in there, doesn't come up. Never used. No evidence of it. Made up. Construction used one time at the hearing. The word construction was used one time. And it was when Mr. Lombardi's attorney asked him, do you work for Center Plan Construction? Answer, no. There was no evidence or testimony about construction at Hatton Field whatsoever. So this is made up. Because you can't go on what you think. Their job was to go on the evidence presented. And if anybody thinks that's not the case, let me show you the consensus opinion. And that means consensus that everybody agreed on this. The second sentence, our responsibility is to review the complaints based on the evidence presented. This decision has to be thrown out because they did not do that. They completely ignored that statement. Now, these are arguments taken from my brief, which I'm submitting to the town council and the complainants, which details all our arguments, a lot of which I've already said. Well, I just mentioned they make that statement about their responsibility. Then Chairman Sims makes his statement that we're going to hear the testimony of these complainants, and then they don't do it. And this is the key, the first bullet point. Where's the evidence that Centerplan will be affected by the June 22, 2015 vote? It's not there. I put words delaying construction were made up because they were. You can't run from this record. This is what happened. And that's why it needs to be thrown out. This is a point that I was trying to make earlier, and I want to just highlight here. The bold is what the Code of Ethics says. So this means that when you're voting on something, if your employer will be affected by the vote, then maybe you have to go to the town attorney, or maybe you have to take extra steps. Will be affected. What is above is what the board majority found. One alleged and two could haves. The word could is universal for possibility. And when you see the remarks, this was all speculation at the hearing. Possibilities. Board member Pomposi openly talking about possibilities, and that's why you see could haves in here. But even with the could haves, they made up the alleged delay costs. It's totally made up. So how did they get to that decision with that record? I don't know. It's either incompetence, the influence of the legal case, or politics, or both. Either way, it's got to be thrown out, in fairness. And does anybody think we're actually here tonight if Tom Lombardi voted yes to revoke the Hatton approval? And does that not prove that this is not about ethics? That this is about the agenda, the legal agenda? Mr. Rosenblatt trying to exploit it for political gain? And I put up their hidden agenda, because if you look at the complaints in this case, very first thing that I noticed that bothered me was that the complaints in this case by Mr. Bruce and Mr. Rosenblatt don't disclose their own interest in this case. Mr. Rosenblatt doesn't. Now, maybe everybody already knows that. But if you're looking at this from New Britain or Hartford or Bristol or maybe the media, the Hartford Courant, and you look at the complaints, you might think they're concerned citizens. There's nowhere in the board majority's decision or in the complaints of Mr. Bruce or Mr. Rosenblatt where they disclose what their actual interest is in this case. They're self-interested parties. And the board majority completely ignores it and doesn't ask them a single question about it. Not one question. And I put that this violates the statement of purpose. The Town of Southington Code of Ethics has a statement of purpose that was added to the code some years later, and it talks about promoting the public's trust in the process. And that's the goal, and that ought to be the ideal. Promote the public's trust. Well, how could the public have trust in this process when if you look at this record from the outside, you just can't tell how bad it stinks? Because you don't know that there's a lawsuit going on against the town and Mr. Bruce is one of the plaintiffs, because it's not in the complaint. And you don't know that Mr. Rosenblatt is the head of the Democrats in Southington, because it's not in his complaint. So you might miss that. That violates the statement of purpose, to not even address it, to not even call this what it is. Again, board member Meade, the only one who did so. And I've made a lot of comments about Mr. Rosenblatt's political agenda, and there is no question that that's what this was about. This is right in the media. This is Mr. Rosenblatt being quoted in the media. That's the arrogance we're going to get rid of. The Republicans don't even listen, and I just couldn't believe that when the Democrats walked out. They wouldn't even listen. And he actually has a slogan that says leadership that listens. I think it needs to be changed to leadership that doesn't listen.
Hey, ladies and gentlemen, please let him just continue without any comments. Thank you.
And I apologize if I'm not getting the name right, but the former chairman said this in the media. This is about the Board of Ethics. And it's cutting it off, but what it says is that you're supposed to have people on there who had served the town already and are not beholden to their party, elder statesmen. Well, I haven't mentioned Mr. Sinclair tonight thus far, but I'm going to now. And I can tell you that if his name was not on the hearing transcript minutes, you wouldn't know he was there, because he didn't ask a single question. Everybody on that board asked at least one question. There's no evidence that he was at that hearing other than the fact that his name's on the front. And Mr. Sinclair is running for Democratic office. Mr. Sinclair is the fundraising contact for the Southington Democrats. I talked about the media smear campaign. Well, the complaints in this case were signed and filed in June and early July. This is a press conference on July 10th. Mr. Rosenblatt's there with neighbors of Hatton Field. And before the Board of Ethics got any chance to hear the evidence in this case or to receive and digest the complaints, Tom Lombardi already had to answer questions from the media about a conflict of interest. This is July 10th. This is 2 months before the Board of Ethics hearing. It's in the media. And I bring this up because what I found in investigating this case is that 2 years ago, there was a complaint lodged against 2 Democratic members of the town council. And it likewise got into the media. And those council members likewise got pretty upset about it. And probably rightfully so. But those same council members have walked out tonight. And both those counselors also got an opinion from the town attorney and did what they were supposed to do. The media wasn't enough. You had to have social media in this day and age. But it's almost principally. So this is the Democratic Town Committee Facebook page. This is July 18th. I don't know. Maybe Mr. Rosenblatt will clarify in the record who's behind this. But this is the Democratic Facebook page, Town Committee. And they're injecting this issue into debate on Facebook. So the ethics case has been removed from the hearing room to Facebook. And if you look at the Facebook page, I'm struck by wondering if there's any other issues they have other than Mr. Lombardi, because it's filled with stuff about Tom. Here's another one. The date is August 4th. This is prior to any vote, any hearing, in this case by the Board of Ethics. It's on the Facebook page. Another Facebook page. This is September 11th. This is after the hearing, but before the decision's been rendered. This is when the decision was rendered. And here's another one with Tom. And the quote, is this really happening? Yes, we are here. And that's, I don't know who's behind that. But it wasn't just Facebook. There was other social media sites. And this is Mr. Rosenblatt. And I just blocked out everybody else because he's the complainant in this case. And this is October 14th at 12:19 a.m. He's up at 12:30 at night talking about this case, chatting online. And I don't know if that's Mr. Rosenblatt or not. Maybe he'll clarify whether it is when he speaks. But this is what's happening. What's supposed to happen if you're the complainant in this case? With all due respect, you're supposed to keep your mouth shut. Because that's what Tom did. Let everybody else, and believe me, there was people on both sides of this issue on this chat. It wasn't just Mr. Rosenblatt. There was people on Tom's side on there too. But the point is you don't do this kind of thing when you're the complainant. And you don't get involved if this is what you're going to want to do. And it goes on and on and on. There's 17 pages of this, so I'm not going to bore you with it. But it's outrageous. And what it suggests is, when you look at all these comments and when you see what just happened tonight, what it suggests is that there was an active, ongoing interference with this appeal process. And maybe Mr. Rosenblatt will clarify in the record what role he had in what just happened tonight. Because you should never have a situation where the complainant in the case is tampering with the process, because it interferes with due process rights of Mr. Lombardi. Now I'm going to sum up my opening remarks by stating that the town council should vacate the Board of Ethics decision and dismiss the complaints against Mr. Lombardi. And Mr. Lombardi, throughout this process, has remained positive and was always looking at this as something not just that he had to go through, but wanting to not have it happen to somebody else again. Seeing some kind of track record developing here in this town. So what can we do to stop this in the future? And Tom has asked, and I'm communicating for him, that the town council appoint a bipartisan committee, Democrats and Republicans, to look at this issue, to look at the town's code of ethics, and can we stop this kind of thing from happening again in the future? And everybody should understand that under the code of ethics in this town, the council has the full, complete, and final authority to take the action they deem necessary. And I'm just going to hand to counsel for the town the exhibits in this case and pass out to the members of the town council our written submissions, which kind of mirror the oral submissions, but you should have those for your records. And I would say that, Mr. Chairman, I'd like to reserve time for rebuttal. As the person who carries the burden of proof on the appeal, we'd ask that we have the last word.
Yes, thank you. We are actually going to take a 5-minute recess.
Perfect.
Thank you.
Thank you.
Okay, it's approximately 8:08. We're going to reconvene the meeting, and we'll turn it over to the attorney.
Thank you, Chair. Councilors. My name is Jamie Sullivan. I'm representing Tom. I sat on the City Council in New Britain for a number of years, so I know your time is precious. Our meetings used to go very long into the night. So I'm going to be very brief. When I was on the Common Council in New Britain, I did enact a number of changes to the Ethics Code to make it more precise and fairer. And before I was on the City Council, I was chair of the Ethics Commission. So Tom, part of the reason why Tom has hired me is Tom is going to, as part of this process, propose some reforms to your ethics code to make it better and more fair. Now, I want to make one point that Attorney Bennett touched upon. He mentioned that the process was not confidential, that the complainants made a media circus out of this. Well, that's not just a matter of good manners. It's in the code itself. The code says that the process of initiating a complaint is a confidential one. And at the state level, okay, if somebody is not confidential in the handling of their complaint, there can actually be sanctions and penalties. So I like things in three, and I'm going to make 3 points. The first is that there was no evidence of a conflict of interest. The complainants didn't even testify. And the board actually admits that the decision was based on speculation and not evidence when it said that Tom's vote could have delayed the construction and could have had an effect on Tom's employer. Could have. Not would have, but could have, which is admitting that it's just based on speculation. Second, what evidence was provided by Tom showed beyond a reasonable doubt that there simply was no conflict of interest. Third, Tom acted in a way that exceeded the standards of the Code of Ethics. He obtained an opinion from the town attorney that there was no conflict, and despite that, Tom did not vote on the Green Skies project. That showed a lot of what my dad called moral courage. He should be commended for doing so, not penalized. For these reasons, this appeal should be sustained. These complaints are flat out frivolous and improperly motivated. The board got it wrong. You can get it right. Thank you.
Thank you. Mr. Bennett, you're all set on your end? You all set? Does anybody have any questions at this point?
If I might, Mr. Chairman, to Attorney Bennett, please. In Section 2203 of the General Rules of Conduct, it says that no town official, member of a board, commission, or agency, or employee of the town shall engage in any business or transaction or shall have a private financial or personal interest, direct or indirect, which is in conflict with the proper discharge of his or her official duties in the public trust and would tend to impair his or her independence of judgment of action in the performance of his or her official duties. My question to you, Attorney Bennett, is this. In Tom's proper discharge of his duties, was his action on the second vote at all limiting his independence or judgment in the action of that vote? In other words, he abstained on the second vote. He abstained on the first vote. The second vote, after checking through with our town attorney, he then went ahead and vote with the rest of the council to agree with the 824, I believe, from planning and zoning. In that discharge, did he at all gain any sort of financial or personal, direct or indirect benefit? That's a very important question, because that is really the crux of an ethics complaint for me. I served for 2 terms on the Board of Ethics, and so I'm concerned only if Tom received any benefit, personal, financial, professional, from any of his vote or lack of vote lack of vote on the second vote, personally with him.
100% no. No personal interest, no private financial interest in any of those votes. Okay? And what's important to understand is that some of those allegations were made, but the Board of Ethics, as flawed as that decision was, they didn't buy that one either. There is no finding in that one-page decision that says Tom Lombardi had any personal or private financial interest in those votes.
In direct or indirect?
Absolutely, 100% no.
Thank you.
Cheryl?
Yeah, Mr. Bennett, 2 questions, if I may. One, has it ever been, to your knowledge, happened where a complainant does not testify in any case, not just this case, but in any case?
Well, you do, not in a process like this, but you do have cases where a complainant may feel that they have evidence through another witness. So it's a matter of evidence and what you think you can prove. But in this particular case, it's a matter of fairness. when you are the complainant in the case and the board chairman says we're going to hear your testimony, so there's a failure 2 times in my view. One, the complainants decide not to testify, right? Number 1. Number 2, the board doesn't ask them a single question. So in a Board of Ethics proceeding, I think it's unique, and Attorney Sullivan could probably comment on that.
They say one of the engines for truth is cross-examination. Tom was robbed of the opportunity to cross-examine the complainants because they didn't testify, and that's fundamentally unfair.
And my second question, if I may, was the ethics procedure flawed because one of the people litigating it was the Democratic town chairman, and one of the members on it was a Democratic current candidate for office? I mean, that seems more a conflict of interest to me.
Well, I think that it's concerning that happened. I think any time the complainant is a political player, if you will, in this case, the head of the town Democrats, what should have happened without question, in my view, is that it should have raised red flags. Under no circumstances should it have happened where that wasn't even mentioned. And I do think it creates some concerns as to whether or not you could expect Mr. Sinclair to ask Mr. Rosenblatt questions about his complaint. But this is the process that Southington currently has. And that's why Tom is reform-minded and looking at this and saying, well, look, 2 years ago, you had Democratic council members on the other end of this. Now you have a Republican member on the other end of this. You all give up so much of your time for this town. And do you want a process where you're using the ethics system to get political gain? Tom doesn't want that. Nobody should have to go through that. And part of his reforms will be that if you're running for office, you shouldn't sit on the Board of Ethics. And maybe you decide you don't want a Board of Ethics, because in some towns, the town attorney's opinion is it.
I would like to, if you could repeat your question. With your background that you stated, I'd like just to hear your opinion on that.
On the, again,
The fact that one of the people on the Board of Ethics is a Democrat currently running for office, while the chairman is the person litigating the complaint.
I don't know that it's necessarily a conflict, technically speaking. And, you know, people throw around the word conflict. I think the complainants throw that word around quite recklessly, frankly. But what I do think should have been done is, out of abundance of fairness to the process, disclosures should have been made that was an interest.
Thank you.
Thank you.
And I just in follow-up, it's important to understand, this is the process. The town council, everybody should understand, they didn't try to take this responsibility on tonight. This is what's in the code. They have to be here. This is the process, and you can't, there's been a lot of talk, and I saw it on social media up until a couple of days ago, talking about, well, what is the town council supposed to do? Should you walk out? Is it the same thing as Mr. Sinclair? It's not. And the fact is, you can't change the process halfway through. So when you have concerns being raised by the other side and saying, well, the Democratic council members have to walk off, you don't change the rules halfway through. That should have been brought up before, or somebody should have thought of having reforms. The fact is, whoever decided to draft the code of ethics in this town knew that this could happen, because it's very clearly in there that this goes to the town council. And in some instances, it goes to the Board of Ed. But in this particular case, it goes to the town council. That's the way it's set up. And the process doesn't preclude somebody like Mr. Sinclair from sitting in judgment. Does it raise concerns? Well, maybe, but it doesn't. It's not improper under the Code of Ethics as it is now. Maybe something should be done about it in the future, but we're in the process that's been started by Mr. Rosenblatt. And if they thought it was a concern, they should have raised it before with respect to Mr. Sinclair, but they didn't. They sat by, nobody said anything, and now they're going to say that you all shouldn't vote. Nobody said anything about Mr. Sinclair voting, and they're going to try to say you shouldn't vote. Well, if you don't vote, who in the town's supposed to vote? The fact is, the code requires you to vote, and it required the town Democrats to vote. They made a decision not to even listen tonight, halfway through the process, not saying a word about what happened in the Board of Ethics. And I'd like Mr. Rosenblatt to even clarify tonight. Did he have something to do with what happened tonight? He's the complainant in the case. Did he tamper with the process?
I have a question on Center Plan companies. You said that they had multiple companies, and the company for which Mr. Lombardi directly works was not involved with Green Skies?
That's correct. He
And
works for Center Plan Development Company. That's his employer.
And
You saw and what you have to,
how is that different from Center Plan LLC?
well, you might have to ask the complainants who failed to prove their case that question. It's a different company, just a point of fact. But what we're dealing with here tonight is the hearing record, the record that the Board of Ethics had to make their decision. That's what this process was tonight. The record that was created does not answer that question. They never sought to introduce any of that evidence. And that's what I said before when they completely disregarded the separate entities. They were acting as if Mr. Lombardi was employed by Green Skies because Mr. Landino is an owner of Center Plan Development Company and is on the board at Green Skies. So they said, oh, well, Tom's employed by Mr. Landino. That's not the fact, and they didn't establish that at the record because it's not true. And again, remember, what's really important about that is when you have this idea of separate entities and what's at play there, is you're dealing with the opinion that Tom Lombardi got from the town attorney was an opinion based on what the code actually says about your employer. It doesn't say anything about any other interest you might have. It's about the employer, the entity Center Plan Development Company. And the fact is that there wasn't a single piece of evidence presented at that hearing as to any interest that Center Plan Development Company has in Hatton Solar Farm. And the truth of it is they have none. And that's probably why you didn't see any of it on the hearing record, because if they had that evidence, they would have come forward with it. They didn't have it, and they tried to confuse the Board of Ethics members about the reality of it. But I'll tell you something, attorneys know that companies are separate. Under the law, that's how they're treated. So it's important to understand that when Tom got the opinion from the town attorney, and let me also say this, I think I forgot to mention this. If you're getting an opinion from somebody in Southington related to this solar thing as to whether you have a conflict of interest, well, the code allows you to go to the town attorney. He did that. Now, this isn't an attorney who's sitting up there in Hartford answering calls when he gets them. The town attorney, Attorney Shota, is all over this. He knows the facts. He knows the different players. He knows the history of the project. He knows the votes. I'll tell you, they would have went on for days if he wasn't at the hearing, trying to figure out what happened. He knew all this. So you have not only a person who knows the town's code, has interpreted it before, but he knows the entire history of what's happening. He's the best person to have asked, and it just so happens that in the code, he's the person you're supposed to ask. And that's what Tom Lombardi did. And in some towns, that's all you need to do. It actually means something. And in this case, it's in the town code, and that's what Tom Lombardi did. 2 years ago, it meant something. The Board of Ethics dismissed the complaints where the town attorney said there was no conflict. What else is he supposed to do?
I have a question that somewhat relates to that. Is the decision of complaints strictly written?
I'm sorry?
The decision from the Board of Ethics
Yes.
is specific, only written. It's
Yes,
not.
as far as I know.
The only reason I ask that is because it says here the effect on Center Plan on the vote could have been a delay in construction and alleged cost of that delay. Mr. Lombardi's vote could have been a material effect on Center Plan, but it doesn't. There is more than one Center Plan entity.
Well, your point, yeah, I agree with you. In fact, they never clarify that in their one-page decision. This is what I'm saying, that not only that, they were putting Center Plan. I think they meant to say Green Sky. I'm not really even sure, because there was just no evidence in that case that Center Plan Development was involved in the construction at Hatton Field. And it's just not true, because they're not. So there's nothing in the record that's contrary to that. Nothing. So once you accept that simple fact, this case has to be thrown out. And frankly, the Board of Ethics understand that they have the power to call witnesses. The code requires them to investigate. And what you heard and saw tonight is the sum of their investigation. A 30-page transcript.
Paul.
Mr. Bennett, the vote on 622 was deemed illegal to rescind because we had a contract already in place. Was that evidence brought to the Ethics Board?
I do not believe that's in the record. That's something I'm pointing out to make people understand. Yeah, to make people understand that the type of vote that was at issue was a motion to revoke something that had already happened. Because if you look at Mr. Rosenblatt's complaint, that's not stated. All right, and that's important to understand that they were trying to undo something that everybody had already voted on.
Just, Attorney Martaccio, the Code of Ethics allows for subpoena power?
I don't believe that the Board of Ethics has subpoena power now. They have investigative power, but not subpoena power.
Okay. Okay.
Most codes allow the board to have subpoena power. I'd be very surprised.
It's there.
I think I saw it
Sure
somewhere.
that it does allow the board to have subpoena power. What it doesn't allow is the complainant or the respondent to have subpoena power, although the complainant and the respondent can ask the board to subpoena witnesses that might have relevant things to say. Where is it? Okay. It would be under hearings.
Yeah, got it. And it's mentioned.
Yeah, it's under
Subpoena first.
it's under 12-14 subsection F. The Board of Ethics shall have the power to issue subpoenas or subpoena duces tecum, that's for records enforceable as therein provided.
Okay, thank you. Any other questions? Okay,
Thank you.
thank you. We'll turn it over to Attorney Rosenberg and Attorney Rosenblatt.
Good evening, ladies and gentlemen. My name is David Rosenberg. I'm a resident here in Southington. I'm also an attorney, and I have the privilege of representing John Bruch, who's also one of the complainants in the ethics decision tonight. I want to make a couple things clear just when we're starting. Okay, this council sits here in the power of an appellate board. Okay, it's not what's called a de novo review, which means we're not retrying the case. We're not starting over. You're here to decide whether or not the Board of Ethics was correct in their decision. Okay? And to do that, we have to start with a couple of different premises. And with no disrespect to brother counsel, what we're here to talk about is the sin, not the sinner. Nobody is here to eviscerate Mr. Lombardi, either individually or his record on the town council. I don't know Mr. Lombardi. From being a resident in town, I've spoken to people that I know and trust, and almost everybody has kind words to say about him. That's all well and good, but it doesn't diminish whether or not his conduct, which was brought before the Board of Ethics, was wrongful. Was there, in fact, under the Code of Ethics, a violation of a conflict of interest? And again, when we talk about this council and what they're doing, we have to start with the rules of the game. What is the standard of review? I don't know. I'm putting that question to you people because you have to make a decision. What I didn't hear from counsel, from Mr. Lombardi, is where the error is. I hear that they don't like the decision. I've heard arguments about Mr. Lombardi's intent and desire to create reform. That's all well and good, but that's not the rules that are before either this this council, or the Board of Ethics. What this council has to decide is whether or not there is evidence, or if there was an insufficient evidence presented. I understand Mr. Lombardi doesn't like it, but there was evidence that was presented. I would note that before the Board of Ethics, Mr. Lombardi was also represented by counsel. Attorney DeNorfia also works in town, well-respected attorney, knows what he's doing. He had the opportunity and the means and the time to call witnesses. He didn't believe he had to. He chose not to. Counsel mentioned that during the process before the Board of Ethics, there was a fundamental flaw because Mr. Lombardi was robbed of the opportunity to have cross-examination. Could not be more far from the truth. Again, he was represented by counsel. He had every opportunity to seek witnesses, to call people who were here in this very chamber when the Board of Ethics was here. Mr. Bruch is in the audience tonight. He was also in attendance on September 9th, the day of the hearing. He could have been called. He was present. He was available. He was not obligated to testify. And while I'll disagree with counsel in terms of the interpretation of the syntax as far as who has to testify or what are the obligations of a complainant when they're making a complaint, those were all followed by the Board of Ethics. Mr. Rosenblatt opened the argument. Both sides made opening statements. Mr. Rosenblatt made a tactical decision to call Mr. Lombardi as a witness. Mr. Lombardi testified, for the most part, very eloquently. And the Board of Ethics did their job. They decided in a bipartisan manner whether or not the evidence that they heard, including the evidence that was in the original written complaints, bless you, was sufficient, whether they believed it. They had the opportunity to weigh the evidence, and they did. And in so doing, they made a decision. And again, this is a bipartisan commission. There are 2 Democrats and 2 Republicans. Okay? The decision that was rendered was a 3-1 decision. That means we can take all of this nonsense about politics and who is sitting and who is not sitting and throw it out the window because 3 members, 1 Republican and 2 Democrats, decided that there was sufficient evidence based on what they heard, based on the evidence that they weighed, that there was in fact a violation of the Code of Ethics. The one dissenting opinion of Mr. Mead doesn't say that there was no conflict of interest. What Mr. Mead found in his dissenting opinion, and what's been mentioned several times tonight, is that Mr. Lombardi did what he thought was the right thing. He went to the town attorney. He asked for an opinion. It was his right to do so under the town code, and he did so. I commend him for it. It's not a get-out-of-jail-free card. To the extent that he got bad advice or incorrect advice, that's not a free pass. To the extent that Mr. Sciotta, who I know and like, gave poor advice, that's a decision of the Board of Ethics. And the Board of Ethics decided that the advice that was rendered to Mr. Lombardi was not correct. And they made that decision after hearing Mr. Lombardi's own testimony that even though he got advice from the town attorney and the town manager, and they both told him that there was no conflict of interest, he still believed that, at least as far as the initial hearing having to do with the selection of a vendor, that he felt there was a conflict of interest, notwithstanding that advice. And he chose to abstain from that initial vote. After the vendor was selected, Mr. Lombardi decided that it wasn't a conflict anymore. Disregarding completely whether or not what gave him pause in the first hearing was somehow there or not there any longer, he made the decision to go forward despite his prior recusal and in spite of the advice he got from town attorney prior to the first hearing. So Mr. Lombardi made choices. Mr. Sciotta made choices. And I don't mean to be flamboyant, but I want to make something that's perfectly abundantly clear. There was a large trial back in the 40s and 50s at Nuremberg. It didn't matter whose advice they got. It didn't matter whose orders they were following. There's right and there's wrong. Okay? And I don't mean to equate Mr. Lombardi with any sort of extremist group. That's not my point. My point is it doesn't matter. The relevancy of the fact that he went to the town attorney does not exonerate him from the decision of the Board of Ethics. I also want to make the point that much of the argument that was brought forth by counsel has to do with political designs and the fact that there's a pending lawsuit. And since the elephant's out of the room, let's talk about that. There is a pending lawsuit by a bunch of residents who abut the Hatton Meadows or Hatton property or Hatton School, however you want to identify it. Mr. Bruce is among the complainants. He's identified in the complaint. It's perfectly clear. His decision to bring this ethics complaint has nothing to do with that lawsuit. That's a separate intervening action. But if we want to bring that lawsuit in, I would bring to the council's attention the fact that on September 24th, 2015, Superior Court in the Judicial District of New Britain already made a finding that there was a violation of the town's code with regard to the process following the 824 referral. Now, the 824 referral, just to have the record be clear, is something that's done by the town and fully appropriate for town-owned properties for development of town-owned properties. What happens subsequent to the 824 referral is what's the subject of the lawsuit. Lombardi has nothing to do with that particular proceeding. And I don't want to mix apples and oranges except to say that.
So why are you saying it?
Yeah.
I please, with all due respect,
Please.
I'm not catching the correlation. I'm trying to get the correlation. I think maybe you threw me at Nuremberg, but I want to understand, Attorney Rosenberg, the correlation that you're trying to make between the legal matter. It's okay that I jumped in here,
Yes.
Mr. Riccio. Between the legal action that happened in New Britain in court and the status of that case and the fact that Mr. Lombardi had nothing to do with that. We all agree with that. I mean, I'm sure even your client would agree with that. He had nothing to do with that. So I'm not sure the correlation that you're trying to bring to our attention.
Well, I'm bringing it to your attention, Ms. Triano, is because counsel's opening remarks is that this case is about politics in the Hatton field. And we went through an extensive audiovisual display about social media and things that are being said by Democrats and Republicans. I would agree with you. If we can strike that all together, I'm perfectly happy with it. That's not this case. This case has a very limited scope. And the limited scope has to do with the fact that Mr. Lombardi works for Green Skies Development. I'm sorry. Sorry. Mr. Lombardi works for, so now you've got me all mixed up, Centerpoint Development. Before the Board of Ethics,
Ladies and gentlemen, please quiet down. Thank you.
Thank you. Before the Board of Ethics, there was a lengthy discussion about the fact that there are several center plan companies, and the identity of the center plan companies is what's listed on the bolded portion of the ethics decision. That based upon the testimony of Mr. Lombardi and the fact that there was an affidavit submitted by Robert Landino, who is the CEO of apparently all of the center plan companies, and there's a common ownership of the center plan companies, as well as the fact that Mr. Landino is also the CEO and chairman of Green Skies, who happens to have a common ownership interest with GRE, Southington GRE 344 LLC.
Record where that is in the hearing record? Because you're making stuff up. Show it to the town council in the hearing record.
I'm looking at it right now, and the Code of Ethics is very specific. And that's why I questioned it earlier, because if you're looking at the decision of complaints, Mr. Lombardi works for Center Plan Development, LLC. The decision of complaints just says, in the initial part of it, just says Center Plan. If you want to, I think the point was made earlier, if you want to join all these companies together to make your argument, that's your choice, but we have to keep this specific to Center Plan Development, LLC. We don't have this broad brush that we can paint in the Code of Ethics. I spent all day reading it, 3, 4, 5 times. It's very specific. And so tonight, going back to the original hearing, the burden of proof was on you. And when I read the transcripts, it doesn't. It's vague. It's one big broad brush. You're lumping. You know. I think your own mistake just a few minutes ago. You said he works for Green. You're just painting this big broad brush. We have to look at something very specific. So if you can address Center Plan Development LLC, then I think we could move forward in a logical way.
Which is why I asked the question of Mr. Bennett. I wanted the delineation of the broad scope of center plan development. That's why I asked the question.
Yes, ma'am. And if I can answer both of your questions, and notwithstanding my Freudian slip, in the preceding paragraph, we're talking about paragraph 4. The Board of Ethics made a decision. They made a finding based upon the evidence that was presented that there is a commingling of the entities. That counsel is correct. Under sections 33 and 34 of the general statutes, you do generally have a separation of entities. So each separate LLC or limited liability company, each separate corporation is a distinct person, no different than you and I. However, the statutes do provide that you can have what's called a piercing of the corporate veil, where if the trier of fact, in this case the Board of Ethics, finds that there is common ownership and common interest and common direction, and where one corporation is nothing but a sham shell for the other or the alter ego of another, they can make a finding as a matter of law that they're not entitled to that separate coverage.
That's in our Code of Ethics?
That's in sections 33 and 34 of the Connecticut General Statutes.
I'm talking about our code.
Our Code of Ethics means that the Board of Ethics made a finding of fact in paragraph 4 that Center Plan Development LLC is part of the broader Center Plan Companies LLC.
I'm sorry. You just said that the Board of Ethics made a decision to commingle. So the Board of Ethics has the power to commingle the companies. That's where I'm confused here.
I'm not saying, and I don't believe I used the word commingle. What I'm saying is, as a
I believe you did.
Yes, you did. Yes, you did.
Let me step back. Not a commingling of the companies.
That's what you said.
These
You said
central figure in all of this discussion is Mr. Landino, who happens to be the chairman and CEO of all of the Center Plan companies and of Green Skies. Based on that uniform ownership and controlling interest of the various LLCs, the decision to me reads that Center Plan Development Company, Mr. Lombardi's employer, is part of the Center Plan Companies LLC, which does have a defective affiliation with Green Skies Renewable Energy LLC, the company that the town of Southington hired to complete the solar panel work. It's paragraph 4 of the decision. That is a decision of the Board of Ethics as a trier of fact.
Excuse me. So what I don't see here is the fact. I see that that's an innuendo that they made, but I don't see that it's that they brought up the facts that, in fact, Mr. Landino was controlling Green Skies. I mean, I hear the innuendo that was made. I hear the leap, the supposed logical leap or illogical leap, but I don't see any fact here that was brought up during the Code of Ethics or the ethics proceeding.
read this whole thing. Okay.
Ms. Lounsbury, I'm going to refer you to Exhibits A and B of the complaint filed by Mr. Rosenblatt. Exhibit A shows the ownership of, or the management of Center Plan Development Company and lists Robert Landino. Exhibit B is an excerpt from Green Skies website, which identifies the same Robert Landino as chairman of the board.
Right, but I could be on the town council, and I could also serve on the board of United Way, and that doesn't mean that there's any commingling. You know what I mean? I mean, you could work for a company, be on the board of another company, but that doesn't, and those are two different jobs that you're paid for from different pockets, one from your own profits and another from probably being on a board, but that doesn't mean there's a commingling unless you can show that there's a commingling. That to me, the profits of one have to affect the profits of the other. If the profits of one affect the profits of the other, I can understand a commingling. Has that happened with Green Skies and Center Plan Development?
I guess I don't quite understand your question. We went from the United Technologies and the town council to
No, what I'm
proof of the
saying is
commingling of funds.
you can work for one company, and then you could serve on the board of another company. But if there's no commingling of funds or no commingling of profits, then I don't see how you can commingle those companies.
The companies are commingled by virtue of the common ownership and common direction of Mr. Landino. Mr. Landino is Mr. Lombardi's boss. Green Skies is the vendor that was selected by the town of Southington to put in the solar installation.
That doesn't prove it to me. I may be dense, but that doesn't prove it to me.
I think the question is when you presented this to the Board of Ethics, having the burden of proof, is because we don't see it here. That's why we're asking these questions. Did you show? Is Mr. Landino the sole owner of Green Skies?
He is chairman of the board of both entities.
No, I asked my question. Does he own it?
I don't know. I'll be perfectly honest. I haven't seen the shares of.
Is he the sole owner of Centerpoint Development?
I don't know. Both entities, as I understand, are limited liabilities companies, so they have membership interests, and I don't know what those membership interests are because they are not required to be filed with the Secretary of State. So we can't go by the ownership interest. We have to go by the controlling interest.
So he has control. You know for a fact that he has controlling interest of each of these entities?
He serves as the chairman of the board of both entities.
Does that mean he has controlling interest is the question?
Yes.
How? I serve on the board of a corporation. I don't own any part of it.
We just said we weren't talking about ownership interest. We're talking about a controlling interest. I'm sorry. Go ahead.
I think it's very confusing for us to paint this broad brush when you haven't shown us who owns what, who's the chairman of what, who has the controlling interest, are the funds commingled. I mean, that's the argument that was presented to us 10 minutes ago. That's, I think, what we need to address here.
With all due respect, not at all. Had we talked about a de novo review, which is starting this trial proceeding all over again, or the ethics proceeding all over again, I perhaps would agree with the council on that submission. You're not here to sit in the board, or excuse me, in the position of retrying that particular decision. You are here in the capacity as an appellate body.
I understand that, but
I'm sorry. I'll let you go. My reference was to the record. That was what my reference was to.
Yeah.
I'm sorry.
And my feeling or my issue here is that we need to look at the ethics decision and say, is it valid or not? Well, when I'm looking at the ethics decision, I want to know what facts they had. I don't see any of those facts in the ethics complaint. So was that delineated or was that just innuendo? That we don't see that. So I don't know what our ethics people were thinking or what was proven to them or not proven to them regarding the Green Skies and Center Plan.
Okay, well, I'm going to answer your question or respond to your point in two different ways. The first is the fact that you have these very legitimate questions actually makes my argument that much easier, because it's not the purpose of this body sitting as an appellate body to retry those decisions. If there were findings of fact and they were made by the Board of Ethics, as sitting in an appellate capacity, you must show that there was some sort of clearly erroneous standard. That's typically what's applied in an appeal. And in terms of being clearly erroneous, you have the facts. Whether you like them, you don't, you disagree with them, you're not sure how they found them, those are the facts. The trier of fact, in this case the Board of Ethics, is entitled to have those facts irrefutable. That's what they determined. The job of the appellate body is then to decide, taking those facts and applying them to the rules, which in this case is the Code of Ethics, was a decision so clearly erroneous that it's a farce, that it has to be reversed. It's not a question of do you agree with it or disagree with it. It's not a question of do you find that an alternative outcome could have come about. It's based upon the law, and the law in this particular instance is the Code of Ethics. Whether you agree with it or you don't agree with it, the Board of Ethics made a finding that there was some relationship. I don't want to use commingling, so I'm not creating more confusion, but there was some relationship between the Center Plan companies as a group and Green Skies. And there was a sufficient enough finding that based upon that relationship between those two entities, Councilman Lombardi, despite his reaching out to town attorney, recused himself from one vote because he believed that there was a conflict of interest. He then chose not to recuse himself from subsequent votes. And again, it's not to decide whether or not the initial decision in whether or not he should have recused himself from the May vote was correct or not. He chose to do that. And he then made a subsequent choice not to recuse himself from subsequent decisions. And the fact that Mr. Lombardi made the decision that there was enough of a conflict of interest to recuse himself and didn't maintain that same standard, that's where the decision was correct. There's no clearly erroneous standard based upon the conduct of Councilman Lombardi. And again, I want to draw a distinction between the sinner and the sin. I'm not saying, and I don't believe my client or Mr. Lombardi, Mr. Rosenblatt, who I'm not speaking for, is trying to say that Councilman Lombardi is not a good person or a good councilman, or that he doesn't have good ideas for reform what is clearly a inconsistent, if not a flawed, piece of rules.
But he's unethical.
Pardon me?
But he was unethical.
Correct.
Is that what you're saying?
That's precisely what I'm saying. In this one particular instance, by making the election to excuse himself from the May vote and not recuse himself from the subsequent votes, he violated the code of ethics. That there was a conflict of interest by his own actions in May. That conflict was not changed, eviscerated, excused for any other reason in any of the subsequent votes. And I think if we read the opinion, the punishment fits the crime. Mr. Lombardi isn't sanctioned in the form of having to pay monetary sanctions. He's not being dismissed from his role as a town councilor. He was admonished for making a poor decision, a decision in judgment, and he was told not to repeat that mistake by voting on any subsequent acts, any subsequent votes involving Green Skies or the Center Plan companies. That's it. This is not a opportunity to diminish his record or what he stands to do going forward. It simply shows that he made an error in judgment. The board found that error in judgment based upon the facts that it, as the trier of facts, was allowed to review, and it rendered the appropriate decision. And while we can agree to disagree about syntax and diction and whether or not the word complainant means that somebody has to actually stand up and complain as opposed to being in the courtroom to be called, or the council room to be called as a witness, at the end of the day, the decision of the trier of facts, the Board of Ethics, stands. There's been no showing, despite all of the discussion, despite all of the audiovisual work, there's been no showing to this council that the decision of the Board of Ethics was clearly erroneous as defined by our laws. Thank you. I'm happy to answer any other questions, but that's it.
I have a question. Attorney Rosenberg, would you agree that our role here tonight is to look at the decision of the Board of Ethics and make a judgment as to whether or not we think that decision was flawed in any way?
No, and only because the definition of flawed in any way is overly broad and overly...
To use your words, erroneous.
Yes, I think it is the job of the town council in this particular instance to make a determination whether or not the findings of fact as made by the Board of Ethics were misapplied to the law or vice versa, and that the outcome of the decision of the Board of Ethics was clearly erroneous, and there's no way that it could have come to that.
Okay, so I agree with you. Do you think it's appropriate then for us to ask questions as to how they came about their decision?
To ask the board, to ask me?
You ask you questions about how the case was presented so that we can understand how they came about their decision.
I'm happy to answer any questions that I can. I think, again, under the Code of Ethics, and I recognize that this is not a court of law, and many of the rules that we're applying are being relaxed. But to the extent that I can answer questions, I'm happy to answer any questions. I would say that the record speaks for itself, and again, under our rules of law, the decision of the finder of fact.
Okay. So
there's nothing that anybody, myself
the
included.
only thing that we have to go on, there's a reason I'm asking you these questions, is that the only thing that we have to go on is the record. Correct?
Correct.
So we have to understand how the record came to be built. Agree?
Not necessarily, no. With regard to findings of fact, with regard to the decision of the majority, which found that, again, I'm reading from the fourth paragraph, that Center Plan Development Company, Mr. Lombardi's employer, is part of the Center Plan Companies, LLC, which does have a direct affiliation with Green Skies Renewable Energy, LLC, the company that the town of Southington hired to complete the solar panel work. That particular statement is a finding of fact.
Okay. Earlier in your statement tonight, you said that in the very first vote, Mr. Lombardi recused himself because he had a conflict of interest.
Yes.
Did he say that he had a conflict of interest, or he recused himself because there was a perception of it? He wanted to avoid the perception of a conflict of interest. Which was it?
To be perfectly honest, I don't have the record in front of me. I will defer to the record. Whatever Mr. Lombardi said and testified to is what he said. It speaks for itself.
I'm going to read to you their brief, which was filed on the record and I believe was presented. And it says that he decided to recuse himself from the vote to avoid even the appearance of a conflict of interest. That's vastly different than he recused himself because he had a conflict of interest.
I apologize, Mr. Riccio. Whose brief are you referring to?
Attorney Denorfia.
Okay.
It was presented as a part of the record. Well, that's why we have it.
Correct.
So when he testified, he said that he wanted to avoid the appearance of a conflict of interest. So if the argument is based on the fact that, well, he had a conflict of interest the year prior and all of a sudden he works for the same company and he doesn't have a conflict of interest, it's washed away. It's not what he said. It says that he wanted to avoid the appearance of a conflict of interest.
I don't mean to joust with you. I don't understand the question that you're asking. If you're saying is whether or not I'm accusing Mr. Lombardi of having a conflict of interest or whether there was just the appearance of a conflict of interest?
No, I'm not saying that. What I'm saying is 5 minutes ago you said to us, Mr. Lombardi recused himself from the first vote because he had a conflict of interest. That's what you said. Am I right?
Okay.
The record says that it was because he wanted to avoid the appearance of a conflict of interest. If in further testimony, it said that he consulted with the town attorney, that he did not have a conflict of interest, but he wanted to avoid the appearance of a conflict of interest. That's a major difference. It's not an admission of guilt in the beginning, which the argument was based on in the second vote. I'm asking these questions because it's just nonsensical to me.
I can appreciate the conflict that makes you say that it's nonsensical, and to the extent that I said that Mr. Lombardi had a conflict of interest, I apologize if I misspoke. Again, the record speaks for itself. The record, which is the findings of fact of the Board of Ethics, is really the only thing that controls. It's not what Mr. Denorfia files or what he claims to have filed. It's not even what I say or believe to be this evening. There is a finding of fact by the Board of Ethics that there was, in fact, a conflict of interest. And based upon the fact that Mr. Lombardi recused himself from the first vote and chose not to recuse himself from subsequent votes, that's the only thing we're really talking about. We're not talking about the Hatton project as a whole. We're not talking about whether or not Mr. Lombardi's vote was meaningful or whether it was the deciding vote. The fact that he chose to recuse himself in the first instance and didn't follow the same pattern in subsequent instances, that's what led rise to the finding of fact that there was, in fact, a conflict of interest.
Thank you.
Just one more question. When you're talking conflict of interest, was there any fact anywhere that Councilman Lombardi received any financial or professional benefit? Or would have received? I mean, I heard the could-haves, the would-haves, but was there any fact anywhere that he received professional or financial benefit?
To my knowledge, to my recollection, there was no finding that Mr. Lombardi received any direct or indirect benefit as a result of his participating in the vote. However, I would submit that that's not the standard. Under the Code of Ethics, it's whether or not Mr. Lombardi or his employer, in fact, received that benefit. And to the extent that the Board of Ethics did make a finding that the Centerpoint Companies LLC is how they were defined in paragraph 4 of the decision, and lumped them all in as a single entity, that they did in fact, or could have in fact, received a benefit because of Mr. Landino's common ownership and common direction of all of those entities, including Green Skies. That's what led to the finding of fact.
So again, it's a could have. We don't know that it did. We know it's a could have.
With all due respect, we don't need to know if it did or it didn't. The Board of Ethics made that finding. It is a finding of fact.
We're here, though, we are here because they are questioning the decision of the Board of Ethics. That's why we're here.
Agreed.
Why we've been sitting here for 2 hours.
Yes, and I agree. This could have been taken care of a long, long time ago, because it's not a decision of this council to say that the Board of Ethics got it wrong.
Yes,
The decision.
It is. It's in our ordinance.
That's what we're
It is
here for.
it is the obligation of this council to decide whether or not there was a clearly erroneous application of the facts to the law. That is the job of the council as an appellate body.
Okay, thank you. Any other questions?
Thank you.
Thank you.
Good evening.
Good evening.
I'm Edward Rosenblatt, a resident of Southington. I'd like to point out, as Attorney Rosenberg has already pointed out, that this is not a trial de novo of the ethics complaints brought against Mr. Lombardi, but an appellate hearing, which unfortunately means that in order to keep to that standard, you will have to disregard a great deal of the presentation of Attorney Bennett. All of the material that he talked about concerning the motivations of the complainants, all the material he talked about concerning an alleged smear campaign, which I vigorously deny, but it's totally irrelevant. All that is before you is the facts that were in the record of the ethics hearing and the ethics board's decision based on those facts. None of the other material put before you today should be regarded on that, including the issue of the potential conflict of Mr. Sinclair as a member of the Board of Ethics. That is not within the range of your consideration because it was not raised at the time of the hearing and is not part of the record. Mr. Lombardi was represented by competent counsel at the hearing. That counsel had the opportunity not only to call upon the complainants to testify, but also to raise the issue of any potential conflict of interest of any member of the Board of Ethics, but did not do so. And therefore, that issue is not before you as a board and may not be considered by you as a board. If you were to consider the issue of conflict of interest, you would have to consider that every member of the Board of Ethics had a conflict. Everyone is politically interested. Everyone cares whether a Republican town councilman is found to be in violation or not. That's why it's an equally bipartisan board. That's why it takes at least one person from each party to make that decision. So that is not what's before you. What's before you are the facts that were presented in the record and the way that the ethics board dealt with those facts. We've heard a great deal tonight about the different entities and their names and their relationships. I would submit to you that we heard way more than is necessary for you to come to an adequate decision about whether the ethics board did or did not make a mistake. The only important part of the relationship between the entities that bears any relationship to your decision as an appellate board is the testimony that Mr. Lombardi gave when in his examination at the hearing, which I'm turning to. I'm looking now at page 4 of the transcript. And I asked Mr. Lombardi, is there a relationship that you're aware of between the company that you're employed with and Green Skies? He said no. I said, there's no relationship whatsoever? His answer, common ownership, yes. Common ownership. That's the only fact that you as an appellate board need to take into account to make your decision as to whether the ethics board did the right thing. The fact that there is common ownership in Mr. Landino means that Mr. Landino, who controls the employment status and the compensation of Mr. Lombardi, is also a common owner with Green Skies. It doesn't matter whether the profits go up and down together. What does matter is that Mr. Landino profits with one company or the other. If one company profits, Mr. Landino profits. If one company loses, Mr. Landino loses. And that goes for both companies. That's the relationship. That's the only relationship you need to know. So of all of the facts that were presented in the record, there are only 3 that you need to know to confirm that there was indeed a conflict of interest. Number 1, Mr. Lombardi worked directly under Mr. Landino. He testified to that effect, who hired him, could fire him, and determined his financial compensation. That's in Mr. Lombardi's testimony. Number 2, that same Mr. Landino is an owner and chairman of the board of Green Skies. And number 3, Mr. Lombardi's testimony that the passage of the motion to revoke, the motion in which he was found to breach the ethical rules, would mean one less project for Green Skies to profit from. Mr. Lombardi works for Mr. Landino. Mr. Landino also owns Green Skies, and Green Skies would have made less money if the motion to revoke were passed. Those 3 facts create an indisputable conflict of interest for Mr. Lombardi, because in making that decision, he had to take into account that he was making a decision that would affect the profitability of the man who was controlling his compensation and his employment. That is a conflict of interest. That is why the Ethics Board decision must be upheld. None of the other facts are really relevant. Those are the things that create a conflict. I know that Mr. Lombardi testified at the hearing that when he recused himself the first time, he was trying to avoid the appearance of a conflict. But that's not what he said at the moment he recused himself. If you take a look at the minutes of that meeting, he didn't say, I'm recusing myself because I want to avoid the appearance of a conflict. He said, I'm recusing myself because of my employment. That's in the record. That was what the conflict was the first time. That was what the conflict was the second time. That justifies the Board of Ethics decision. That's my presentation.
I have a question. At your third point about Green Skies losing, having one less site.
Yes.
Is that a fact?
That's what Mr. Lombardi testified. It's in the record.
But he testified that Green Skies would no longer have a site it had in school?
Let me get to the right page of the record, please.
I believe it's page 7 and 8.
Thank you. Bear with me one moment, please. Page 8 of the transcript. My question. Well, would it not mean that there would be one less project for Green Skies to do in Southington because one of them had been revoked? Answer, okay, meaning yes.
Please read the next question and answer to be complete.
So if it was one less project, it would have meant less business for Green Skies, wouldn't it? And he would not comment on that.
But
It says, if you read the comment,
I'm not going to comment on it.
on the operations of Green Skies. Like I said, I have no conflict of interest. It was determined. And what they do as a business is entirely up to them, was Mr. Lombardi's answer.
And if you read at the top of the page, so I didn't ask that. I asked, wouldn't a yes vote, or if it met Mr. Palmieri's motion had prevailed on June 22nd, wouldn't that have meant that there would be one less school project for Green Skies to do?
Yes.
I don't know the answer to that. I don't know where it would.
Well, that's a little bit of an inconsistency, isn't it? Because a minute later, he said it would have been one less project to do.
No, I don't know the answer to that. That's what he said. I don't know the answer to that.
With all due respect, Attorney Rosenblatt, you led him to the conclusion that you were looking for by taking the answer okay. He never said yes.
Do you take okay to mean no, or anything other than yes?
Yeah. I mean, I take it to not mean either, actually.
That is as much a yes as there can be without spelling it Y-E-S. But nevertheless, there's certainly, you certainly would not be considered erroneous for the Board of Ethics to interpret okay as a yes. You certainly can't fault the Board of Ethics and say this decision is erroneous because they thought okay meant yes.
Is that what they thought?
What is in their minds, nobody knows.
So was there any
All
other...
I'm saying is these three facts that I've established are enough to show that there was in fact a conflict of interest.
The third, what you call fact, do you have any other factual evidence that if this got turned down at Hatton School, that they would have one less site?
Well, let's look at what the motion was. Prior to that motion, the town council had approved solar installation projects for several different locations. On June 22nd, a motion was made to revoke the approval of one of those locations.
Was the motion to revoke the solar array in the field, or?
No. It was a motion to revoke the project at Hatton. There was no mention of the field or the exact location. It was just to have one less installation project in Southington.
Yes. It's recorded. Thank you. So I think my question is, were there ongoing discussions that if the solar array in the field didn't come to pass, were there discussions as to what other options were there at that site to relook at the use of the roof, et cetera, et cetera?
That issue is irrelevant.
It's irrelevant because
Yes.
you're stating it as fact that Green Skies would have one less solar array, and I've been in the discussions myself.
It could be that some other motion or some other action of the town council would expand it, change it, and do something else. But the vote that counted, the one in which there was the breach, was the one to revoke a project and reduce the number of projects by one. In fact, my question to Mr. Lombardi, that he answered okay, really wasn't even necessary. I did it to make it obvious. It's obvious that if that motion had passed, there would be one less piece of business for a company owned by the man who controls its compensation.
If you read down further, though, that's why there's so many questions tonight. He said, okay. The next line, the question you said, okay. The next line he said, you are drawing that conclusion yourself.
That's his way of not answering the
And then you
question.
said,
But
I think
that's his way of not answering the question.
Right, and that's,
Ladies and gentlemen, please.
No, and then you said, I think it's an obvious conclusion. So again, is it innuendo or fact? That's what we're trying to, that's what I'm
It's a
trying to
simple
do.
question.
It is
Innuendo
a simple
or facts?
question.
Or
If the
fact?
motion had passed, can there be any doubt that there would be one less piece of business as of that moment for Green Skies to do in Southington?
And then-
That's very
and
obvious.
And your statement is, if there was one less project for Green Skies to do in Southington, it would have affected the amount of income that Green Skies would make from its projects in Southington, wouldn't it? And Mr. Lombardi's reply is, again, you are making assumptions that I don't have the answer to. I am not involved in Green Skies business. And Attorney Shota even had to intervene in this, and Attorney Shota said, you understand that the question was asked and answered a number of times.
If Mr. Lombardi, I'm sorry, if Mr. Lombardi says okay, and then he says you are drawing that conclusion yourself, does okay still mean yes?
Those are two different statements he made to two different questions. But even if I had never asked the question, even if he had never given an answer, it's clear on the face of the facts that the passage of that motion would have resulted in one less project for Green Skies.
That's not true.
That's what the motion was. Are we gonna subtract one project from those projects that have all been previously approved? That fact is inescapable.
Please, Mr.
Yes.
Chairman. Attorney Rosenblatt, in the Code of Ethics, what we started off reading and what I questioned prior counsel was about the direct and indirect financial or personal interest. Would Mr. Lombardi profit in some way in this in his vote? And one of the things that, and you know, none of us are attorneys, Ed, you know that. We're just trying to get the facts. If we're not on protocol, please forgive us, but we're trying to get the facts as best as we can understand. And I might add, the Board of Ethics are not attorneys either. And so sometimes we might not get exactly what it was supposed to be. But my question is this. You mentioned something about mutual and direct correlation between the companies. You see, I keep going back to that. We keep going back to that. It was interesting to hear Councilwoman Urillo and the chairman, because we keep going back to that, because if someone has a bunch of different companies, what is the correlation? How in the world can we say that someone from company A is going to benefit by company D or F or L over
It's
there?
very simple. If Company A and Company B are separate companies that have common ownership, as Mr. Lombardi testified they have, then the profit to that common owner goes up if either one profits and goes down if either one loses.
But do both companies, if you're surmising that, have the exact same ownership?
It's irrelevant.
Why?
It's irrelevant because the only thing that counts is whether Mr. Lombardi had reason to think or reason to suspect or reason to have any level of feeling whatsoever that a decision he made on that vote would have any effect, any possible effect on his income or his employment status.
Even though that vote was only a matter of policy, it had nothing to do. He recused himself when the decision was made. But that vote, Ed, was specifically on policy and whether to accept the 824.
I take issue with that. It was not strictly on policy. It was a motion to revoke an approval of a previously approved project. We can talk all day long as to whether it was
But a project
illegal.
that we were already in contract with.
So that goes to the issue of whether or not it was a legal motion. I have no opinion, and that has no relevance to the decision of the Ethics Board. It may well have been an illegal motion. But nevertheless, the effect of the motion, if passed, would have a direct business effect on an entity owned by the man who controls Mr. Lombardi's compensation, and that's the conflict. It's inescapable.
So is the conflict, I think this will be my last question, is the conflict, did he receive compensation?
So is the compensation a salary, or is the compensation based on commission, based on the number of projects that the company has?
That's not the issue.
Yes, it is.
It's not, I beg to differ. The issue is, did he have reason to suspect, reason to even think that of his vote, because it affected the profitability of the man who controls his employment and his compensation, might have some kind of effect. We don't have to prove that Mr. Landino came to Mr. Lombardi and said, "You better vote yes or you're fired." We don't have to prove that. All we need to prove is that there's a possibility that it appeared in his mind that his behavior might affect.
That's not what the code says. I mean, that's going way out and above.
Yeah.
I don't think so. When
Back to Clinton, what is
When
this?
council presented that section of the code in the projection, there were a few dots because the entire section was not presented to you. So allow me to read it to you. This is section 28-5A of the Ethics Code. A conflict of interest exists if the officer, official, employer, or member of any town agency has a private, financial, or personal interest in the outcome. That part was not in the projected portion, only the part about whether your employer is going to profit or not. Mr. Lombardi definitely had a private and personal interest in whether a company owned by the man who controls his compensation has more or less business.
You know that.
How can you avoid that?
You're surmising it, though, I think is the crux of this whole thing.
All it
They're
has
assuming.
to do, all it has to do is be a possibility that he was worried, that he might worry about what his boss would think about
But
his
what
vote.
was the fact that showed he was worried? I mean, I didn't see that in any testimony.
We don't need to prove that he was worried. He had a personal or private financial interest. Only the fact that it was a possibility is enough to bring that within this definition.
But earlier, Mr. Rosenblatt, you specifically said, look at the facts, look at the facts, look at the facts. And now
Yes.
you're saying there might be a possibility somewhere in the cloud that it could exist. That's
the
would have,
standard.
could have, should have,
That-
and that's allegedly and everything
That's
else.
the
That's
standard.
not the fact.
The fact is that Mr. Lombardi was presented with a situation where his vote would affect the profitability of a business controlled by his employer.
The fact
That
is
sufficient.
supposition. No, that's the fact.
Yeah, that's.
Suppose. Let's just suppose. I mean, you could wipe out the entire town council if that was the case.
Well, not necessarily. But let's take this logic to the next step. Let's say that it was determined that, just for argument's sake, that it was determined that that motion was legal and not illegal, and that it passed. And then another person who lives near another school project that was getting solar panels asked the town council to revoke that. And another one passed, and another one passed. Then there would be no business for Greenside in Connecticut.
Oh, my gosh.
So if it
that's
applies to all, it applies to
Brenda.
just one. The
No,
argument applies to just one.
All right.
Is there any other questions for the attorney?
I do need to make something, just for the sake of full disclosure, Ed, and it has nothing to do with this hearing, but I do want you to know that I've been approached, and for everybody else to hear this too, I've been approached by two very prominent Democrats asking me to approach Mr. Lombardi to have him not appeal this matter. And because it came from two people, I know other people have come to me and said it's come to them. I can't speak for them. But are you aware of that movement within your party to approach us to move and ask Mr. Lombardi to not appeal his decision at all?
I most certainly am not.
Thank you. I want to know.
Okay. Any other questions? Thank you.
Yep.
Despite the fact that there was a lot of improper argument there that's not based on the record, I kept having to write more orange notes on my pad because there was just so many things wrong with what was said. And I hope that council can understand that that's why Mr. Lombardi is kind of outraged, because to have a man's reputation who everybody is saying has done good things for this town, and to have his reputation at stake and then to treat it in this manner is wrong. And it would be wrong if it was a Democrat, and it'd be wrong if it was a Republican. You don't do that. And this is what's sometimes wrong with government at the local, state, and national level. You lose good people because they don't want to deal with this nonsense. But Tom, his commitment to the town should not be questioned. I can tell you that I questioned it. And why would you want to go through this? Why would you want to deal with this? You're a CPA and MBA, you're a young professional, you're giving all your time to the town, and then you have to deal with this nonsense. Not at all. Tom's commitment is he's undeterred, and is more focused on getting it right for the future so that this doesn't happen again. And with respect to the comments made by Attorney Rosenblatt and Attorney Rosenberg, I just wrote down here the record. They can't get up here, and this is what happened at the Board of Ethics hearing. What you just saw there is an example of what happened at the Board of Ethics hearing. Just frankly making stuff up and not putting it in the record. When Attorney Rosenblatt says these things, it's not the law according to Mr. Rosenblatt. You have to prove them. You have to put evidence in. You cannot sit there and pontificate. And in fact, the very process that started this, his complaint, is false. Paragraph 6 of his complaint, he inappropriately describes what the vote was. It's wrong. He says that the vote was to approve the project, including the awarding of certain solar panel installation work to Green Skies. The town council knows that that is not the case. You were there. The Board of Ethics wasn't there. So you can begin to understand maybe how they got this so completely and utterly wrong. And with this standard, the comments about the politics and the makeup of the Board of Ethics, let me be clear that my harshest criticism is for Chairman Sims. He was the one who said on the record we're going to hear from the complainants and then didn't ask him a question. So it's not a matter of politics on the Board of Ethics. It's a matter of competence. And the clearly erroneous standard that Attorney Rosenberg would like you to have is not in the town's code of ethics. That is another thing that's just argument and being made up. Even if it were a clearly erroneous standard that you have to find that the Board of Ethics decision was clearly erroneous, I think we've pointed out about 10 errors here tonight at least. Even under that standard, you need to throw this out. You can't go beyond the record. And I do want to comment about this recusal from May of 2014. We point this out in our brief. And if you look at the hearing transcript, they locked onto that and were penalizing Tom for that and making an assumption that, wait a minute, you recused yourself in 2014, you are in violation a year later. They're actually penalizing conduct that the code promotes and saying that if you recuse yourself to avoid even the appearance of a conflict, which is not in the town code of ethics, if you go above and beyond what's required, when no conflict actually exists, well, you've now said for all time that there is a conflict. They're actually punishing and penalizing good behavior. It makes no sense. It's poor policy making, and it was right to point that out, that it's an error to focus on that. Now, I heard things talked about crime and the Nuremberg trial. I mean, this is just, now Tom's a Nazi who's committing crimes. I mean, it's ridiculous at this point. And what the council has to do is look at the record, and you'll see that there's no evidence in that record about profits, about delay costs, construction. I already pointed out the basis of the Board of Ethics decision is delay costs. That's what they said in there. Where is that in the record? Try to find it, because it's not there. Nobody talks about delay costs. They don't even talk about who's doing the construction, let alone center plan development. And we all know, if anybody reads the media, the newspaper articles, no center plan entity is doing any work on the solar projects in Southington, let alone center plan development. And there's no evidence to that, to the contrary, in the record. The discussion about profits and who profits and who doesn't, not in the record, not established. None of this. And they'll have you ignore all the corporate entities at play here and commingle them and put them all together and completely disregard it. Even if you look at the Board of Ethics decision, and we're talking about all these findings of facts that were made, but that's why we're here, because they made findings of fact that have no support in the record. So you can't go from the 30-page transcript to this one page. You just can't, because it's not there. And then the talk about the website, well, the board majority references the website expert from 2009 and puts it in the decision. Well, guess what? That's not in the record either. Nobody offered or said a word at this hearing about a website. It's not in the record. There was no evidence submitted, no testimony on it, nothing. And there was a lot of talk about controlling interest and majority interest. None of that's in the record. It's not there. And I could go on and on, but I'm not going to do that. I want to end with what the standard actually says about the allegation that I omitted parts of the Code of Ethics. And that's why I wanted to point out that it was important to understand that there was a difference between having a personal interest and a private financial interest and what the Board of Ethics actually found. You need to look at the language that says will be affected. And as a matter of fact, I'm not the one who put those space dots in there. You know who did that? The board majority. They're the ones who put it in there that way. You see that in the first paragraph?
Yes.
That's not me. I copied and pasted from the board majority's decision. I wasn't trying to hide another aspect of the code. That's what the board majority put. And the reason why they cut that other part out is because they didn't make a finding of that. And that's why I started this off saying, understand that Tom Lombardi had no financial interest or otherwise in any of these votes or any of these projects. Even the flawed Board of Ethics decision didn't find that. They only went after the employer thing, and then they got that wrong and went on two could-haves and an alleged. And that's just not good enough to smear a person's name. That's all I have.
I have a question on that.
Yeah.
So it says in alleged costs of that delay. There was no testimony anywhere about the cost of delay of the project.
You don't have to take my word for it. Take the transcript, PDF it, and do a term search for the word delay. It doesn't show up anywhere. It's not there. And then if you do a term search for construction, it's going to come up once. And it's when Mr. Lombardi is asked if he works for Centerpoint Construction, and his answer is no.
Thank you. Any other questions?
No.
The flaws are many, and some are procedural. The burden of proof being shifted onto Tom. Some are substantive. But let me close with 2 points. Tom relied on the advice of Attorney Schroeder, the town attorney, which he's entitled to do under the Code of Ethics, 28-17. Attorney Schroeder has been practicing for 15 to 20 years as town attorney. Who better than him would know what the proper advice to give? And Tom was entitled to rely on that advice. It's fundamentally unfair for him to go to an attorney, ask for some advice, rely on it, and in fact do more than what he was advised by way of not giving the appearance of any kind of impropriety. And the other issue is this: the record shows that Center Plan, okay, not just the gloss, but all the Center Plan companies did not even do any work in Southington. So if they didn't do any work in Southington, how could they have benefited? That's what you have to decide. How could they have benefited? They didn't do work in Southington. They clearly couldn't have benefited. And that's what you have to decide. Thank you.
Thank you. Any questions from the council?
No, but I'd like to review the affidavit.
Hold on 1 second. No, I don't think that's appropriate. I think the rebuttal was the way we lined this up in our phone call. So, any other questions? What I'm going to do is I'm going to take an adjournment here. I will allow for deliberations in, it could be 15, 20 minutes. I can't guarantee it. I don't know if there's going to be a decision tonight. I have no idea. That's not for me to decide. It's for the council to decide. But we're going to take a recess, and we will we'll reconvene here, and the deliberation would be in public. And that's all I can tell you at this point. So if you want to stick around, we're happy to have you. It'll be at least 15 to 20 minutes.
What I would say is that we are going to deliberate in public. We don't want anything anyone to think that anything bad is going on. We're going to deliberate in public so everyone can hear it.
We'll take a recess. Thank you.
Sorry.
Good evening again. We're reconvening. The time is 9:55. Thank you for your patience, everybody. And we're going to open this meeting back up, and I would entertain a motion in which direction the council would choose to head on this.
Mr. Chairman, I would like to make a motion that we vacate the decree of the Ethics Board and dismiss all charges.
I'll second that.
Any discussion?
Yes, Mr. Chairman, I want to say on the record that sitting here this evening, I would be rendering this decision no matter what party was involved in this, because it is very clear to me. One of the key factors for me has been the fact that we keep talking about the record, but no one has made reference. We've been asking over and over again about Councilman Lombardi and his relationship to his company and to the parent company and to the different companies, and no one can give us an answer. So I went back through the record, and thank you, Attorney Bennett. However, there is an affidavit, sworn affidavit, accepted affidavit by the Board of Ethics from Mr. Landino. And in that, this is Tom's boss. He says this: Center Plan Development Company, LLC, has no business dealings, direct or indirect, with Green Skies Renewable Energy. Tom Lombardi has had and does not have a financial interest in the activities of Green Skies Renewable Energy. Mr. Lombardi has not had and does not have a personal interest and does not derive any benefit or detriment from any operations or results of Green Skies Renewable Energy. And finally, Mr. Lombardi has had no involvement in any of Green Skies Renewable Energy's proposals, biddings, operations, including the Town of Southington's solar initiative. And that spoke volumes to me, because this is the man who we keep talking about, and we've accepted his affidavit, and he clearly states that there is no conflict between Mr. Lombardi and his employer or Green Skies. The other thing I want to say is this. In the opinion of the Board of Ethics, it says this: this vote is in no way an indictment of Mr. Lombardi's character or commitment to the best interest of the town of Southington. Well, if it's not an indictment of Mr. Lombardi's character, I don't know what is. And so clearly, and we've heard, well, it's the sin and not the sinner, and and all of that. That's ridiculous. When someone comes against an individual, there better be a direct conflict of interest in this case, or it doesn't fly. And I don't care what party you're in. I don't care what your situation is. That's the code of ethics. I served for 2 terms on there. I've dealt with many hearings. it is clear to me that the vote that was taken was erroneous. Now, we've talked a lot about politics tonight. I don't even want to go there. I'm saying that the vote itself was erroneous. You can have a million different excuses, but when someone focuses on an individual and targets that individual for an ethics complaint, a young man who did everything right, who went to the town attorney, as every single one of us counselors do when we have a question, received good, solid information, and then is told, oh, by the way, guess what? You've violated the code of ethics, and there's no proof of that. How in the world can anyone be indicted in that? He did everything right. And not only that, we've cleared up the fact that there is no conflict of interest with this company, which was the basis, I believe, of the majority of testimony. Now, I want to just say one more thing, and then I think my other colleagues have something else to say. And that is, I feel for the neighbors, my neighbors up on Berlin and all. I know this has been difficult, and I believe that one of the people bringing up this ethics complaint was of a pure heart and really wanted to have some answers. I don't know if he was influenced by someone or not, but I accept that as being clear. But when the Board of Ethics violates its own code, what can we do? We can only do what's right. So therefore, Mr. Chairman, I would vote in agreement with the motion and move to break the order of the Board of Ethics to rescind their designation on this.
Any other discussion?
Well, Mr. Chairman, I am very grateful that I did not have to sit before that ethics board, because what I heard tonight, and I really have spent the better part of today going through the ethics hearing minutes and going through the Board of Ethics as it is written in the town. What I heard tonight was a decision for Tom based on innuendo and supposition. I did not see any facts. So as I look at the decision on the board, their key issue seems to be Green Skies joined forces with Centerpoint Company shortly afterwards and instantly gained access to a new level of financial, legal, design, engineering, construction, and maintenance support. Within 2 years of the partnership, Green Skies, backed by the financial and professional strength of Centerpoint Companies, had successfully constructed and financed several large commercial systems. This came from the website of Green Skies Corporation. Well, any of us who have been in business before, when there's been mergers, so, I worked for Aetna, there's mergers, I've worked for other, this is the kind of language that happens when a merger takes place, but it doesn't give any details. It just, good feelings about how this is going to strengthen the company and the stockholders. When we look at the affidavit, which Councilman Triano read, it says just the opposite. And when I asked, and I think it was asked several times, did Tom receive any kind of benefit from his vote, even though his vote was approved by the town attorney? Did he receive any kind of benefit, personal, financial, or professional? No, he didn't. So where is the ethics violation here? To me, it's innuendo, it's supposition, it's could, it's would, it's he said, she said, but no facts. This ethics decision was based on no facts that I could find. So I applaud Tom for wanting to take a look at this and review it and come up with a more fair ethics. That's the best thing that could come out of this debacle. But I in my mind, I do not understand how anyone on that ethics board that used any kind of logic acted the way that they did. So I certainly will vote to vacate this decision.
Any other discussion?
First, I'd like to thank all the attorneys for presenting to us, shed new light on it for us. We read the articles, but when you tear them apart and build them back up, again, I still stand on the could, and alleged, as not being a conflict of interest. There's no proof there, and I am going to be voting to
Vacate.
vacate. Excuse me.
Dr. Rulo?
Thank you. In this transcript, as I read it, Mr. Lombardi did the right thing in recusing himself from the selection of a vendor because he worked closely with Green Skies and Center Plan. Thank you.
Right.
Sorry, I'm going to start coughing in a minute. And that would give the appearance of a conflict of interest. And then after that, it was a policy decision. I agree with my colleagues here about fact versus innuendo, and we have to go along with what the facts are. So I will be voting in favor of vacating the decision. And I also would like to thank the attorneys and the public for coming out on this long evening.
Thank you. I want to start out by saying that I don't want anybody in this community to think that any of this procedure was done half-heartedly. We all took this extremely seriously to the point where I advised any of us on this council not to have any conversations with Mr. Lombardi for weeks on this matter, because I wanted us to be coming into this room with a clear conscience and hear both sides of this case. What we have to do tonight is we have to prove that there was a clearly erroneous application of facts on behalf of the Board of Ethics. And, we asked a lot of questions tonight, and because we're looking for answers. And when we asked so many questions and we got a lot of vague responses, I sat in the ethics hearing, I read the transcript. The answers that we got tonight were as vague as the answers that the Board of Ethics got on that night. And I'm not going to guess why they voted the way they did. We just have to look at the facts and make our decision based on that. But when we look at items such as when Mr. Lombardi was asked, if you look at page 8 of the transcript, he was asked about the project being removed by Attorney Rosenblatt. And I think we all heard Attorney Rosenblatt's response tonight when Mr. Lombardi said, okay, you are drawing your own conclusion. Attorney Rosenblatt took that as a yes. I'm not sure that anybody in this room, especially the people sitting up here, would agree that that's a yes. So if you take that, and I just want to read it again because it's really stuck with me all day as I've been going over all this paperwork. The effect of Center Plan on the vote of June 22nd could have been a delay in construction and alleged costs of that delay. Mr. Lombardi's vote could have had a material effect on Center Plan. And, I think my colleagues here this evening asked numerous questions, show us the facts, give us something to back up the fact that the Board of Ethics made a decision based on facts and not some other reason. And I didn't see it. There was no clear and concise evidence that was presented at all in any of this. So for that reason, I will go along with my colleagues. And if there's no other discussion, I would ask the town clerk to make a roll call, please.
Victoria Triano.
Yes to vacate.
Stephanie Urillo.
Yes.
John Barry.
Madam Clerk, Mr. Berry has chosen to recuse himself from this hearing.
Paul Champagne.
Yes to vacate.
Cheryl Lounsbury.
Yes.
Dawn Maselli.
Madam Clerk, Ms. Maselli has chosen to recuse herself from this hearing.
Christopher Palmieri.
Madam Clerk, Mr. Palmieri has chosen to remove himself from this hearing, recuse himself.
Michael Riccio.
Yes, it passes 5-0. Thank you. Be looking for a motion to adjourn.
Motion to adjourn.
All in favor?
Aye.
This meeting is adjourned. Thank you.